All right, closer to home now, a domestic violence survivor is appealing her murder conviction today. The case is a step toward a constitutional challenge on how courts handle gender-based violence matters. Known as the Palm Ridge mother, she killed her partner during a struggle back in November of 2018. Her lawyers are now arguing she acted in self-defense during that abusive incident. This case also highlights concerns about how the justice system treats survivors of violence. Legal experts and advocacy groups are watching this case closely. So are we. It's all unfolding at the Palm Ridge Magistrates Court. Let's listen in.
I was going to say that the court may still choose to refuse condemnation. I hope the state isn't going to attempt to argue no condemnation because of what they've said in their heads of argument on the record. But can I say that to the extent that the issue of condemnation has to be dealt with, you already know, Your Worship, from the explanation under oath on affidavit, what the explanation for the condemnation is. That largely has to deal with transcription issues, which the state rightly recognizes has nothing to do with our client, and therefore our client shouldn't be prejudiced. What we know is one of the requirements under the test for condemnation and where the condemnation should be granted is whether there are prospects of success in the underlying issue. And so when an invitation is made to your ladyship to split the question from condemnation from the question of merits, I would respectfully submit to your worship that you should decline that invitation, because if I can demonstrate to your ladyship, your worship, I don't know what I'm calling your worship at this moment in time, all due respect, regardless of the name used, if I can demonstrate that there are merits in this application, then that should swing the court in favor of granting condemnation. Because otherwise, the consequence of the approach that my learned friend invites the court to take would be to deny an applicant who has made out a case on the merits where there's an issue of constitutional rights in contestation, deny them their day in court simply on the basis of a delay that has nothing to do with them. And that we would respect does not feature in the interests of justice. So, Your Worship, if that issue falls to the wayside, let's go to the test for leave to appeal.
Before we proceed to the test for the leave to appeal.
Yes, Your Worship.
The court would like to hear the state on this aspect, that the application for condemnation not be heard first regarding the time periods prescribed
Yes.
by legislation.
Yes, I'm indebted.
Mr. Prosecutor.
Your Worship, the contention of the state is that we have to deal with condemnation, because this the ruling on the condemnation will then determine whether the court grants the condemnation. If the court does not grant the condemnation, then the application for leave to appeal in itself cannot proceed. It is the starting point upon which we have to deal with. Even though my learned colleague is of the submission that this can be dealt with in between the application. It is the starting point of the application for leave to appeal as to why was this application filed late. And the state contention is that we should first deal with the condemnation, that the court should first give a ruling on, and we move on from there.
Anything else?
Yes, that will be all, Your Worship, as the court pleases.
Mr. Primod, just on the condemnation application being heard first. And
all I'll say is, having regard to what the state's heads of argument says, is that the condemnation issue is unopposed. And I don't know whether my learned friend was suggesting that it now is opposed, but as far as what the heads say, it's unopposed. And that should weigh, with all due respect, as an additional factor as to why the court should grant condemnation in circumstances where there is a constitutional issue at play.
the court will pronounce a quick ruling on this aspect, given that the state and the defense disagree on the procedural aspects and the way forward regarding both the application for the condemnation and thereafter the application for leave to appeal. The court is of the view that the state contention in this regard is indeed correct, that the procedural time limits have not been complied with, and that the application for condemnation first be heard, the court make a ruling on this aspect, and that the application for leave to appeal on the merits may then proceed. Even though it is unopposed, it is proper for this question to be disposed of at the outset.
I'm indebted.
Yes, so you may proceed on the application for condemnation.
Thank you, Your Worship. I'll start there then, if I may. What Your Worship will know is that we deal with the reasons for condemnation extensively in our heads of argument at page 14 to 15, at paragraphs 72 for 75. The 4 points I would make in favor of the condemnation, hopefully not to repeat myself from a short while ago, are these. The first one is that good cause is present. The good cause being present in the circumstances is that a significant amount of time was wasted in attempting to procure the transcription from the court for the purposes of advancing the application for leave to appeal. That, with all due respect...
Just a minute. Where is the accused, the applicant?
There she is.
Are you not going to call her into the... No?
No.
All right.
No, Your Worship.
All right, now proceed then.
So the first issue is obviously the issue of the transcription. The second issue, Your Worship, is that there is also a substantive application for condemnation in front of you, and in that substantive application for condemnation, one of the significant reasons which are advanced is that the underlying constitutional issue, which implicates my client's rights, my client's personal liberty, and fair trial rights, are at stake if condemnation is not granted. And having regard to the seriousness of those issues in dispute, it is necessary we would submit to grant condemnation so that the merits may be ventilated. The third one is obviously that the state doesn't oppose condemnation, and we would respectfully submit that that's because the state is not prejudiced by the granting of condemnation. Because even if Your Worship grants condemnation but refuses leave, the state would not be prejudiced by that. But if Your Worship, and ironically, if Your Worship grants condemnation and grants leave, the state is still not prejudiced by that, because my client would continue to remain incarcerated even if leave is granted. And no one is asking in front of Your Worship at this moment in time that that position be changed. So that's the third substantive reason as to why condemnation should be granted. The fourth reason, with all due respect, is that this matter has now been enrolled in front of this court, if I'm not mistaken, from as far back as 2023, when the notice was filed. I might be mistaken on that. I'm trying to catch the eye of one of my juniors to confirm that, and now they've looked at me, so I'm sure they'll confirm it in due course. But the point that I was making is that a significant amount of time and resources have been expended on the furtherance of this matter. And in circumstances where this court is now poised to make a determination on the merits, with all due respect, it would strike us as being a waste not only of judicial resources, it would also be a waste of state resources, because the state has put in effort to try and answer the application for leave to appeal. Not to mention, of course, that even though my client is represented pro bono by the attorney in the matter, as well as members of the council team, that would be a waste in circumstances where the merits are in front of the court and the court can make a determination. Just to correct myself, I said that the application for leave to appeal was from 2023. I made a mistake. That was from the 6th of August 2024. So with all due respect, Your Worship, those are four substantive reasons that the court needs to consider in the determination of condemnation, and we would say that those substantive reasons justify condemnation being granted in the circumstances.
For the record, Mr. Primode, the applicant has been substantially out of time, correct?
Yes, that is correct.
Do you wish to place on record the chronology for the record, or do you not deem it necessary?
Your Worship, I'm going to ask if one of my learned juniors can call up the substantive affidavit in the condemnation application. This comes from paginated page 8 of the condemnation affidavit. You will see the explanation starts under the heading explanation for the delay at paragraph 13, where the deponent, who is the instructing attorney or the erstwhile instructing attorney in the matter, says the delay in bringing the application largely has to do with the difficulties in obtaining the transcripts. Then at paragraph 14, the 21st of October 2022, Kells, who is my instructing attorney, emails the Department of Justice to request certain transcriptions. There are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 requests that are made. 14 individual requests for transcription. On the 21st of October, which is the even date, a response was received, and the indication was given that an alternative email address be used, but there were some problems with that email. And so 2 weeks later, there was a follow-up with no response. That follow-up was on the 15th of November 2022. No answer from the DOJ. Then there was another follow-up on the 6th of February 2023 to follow up, and again no response was received. That happened again on the 14th of February 2023. Not the best Valentine's Day gift one should receive, but again there's no responses. Then on the 14th of February 2023, my attorneys of record physically went or called the Department of Justice. I apologize. They were provided with 3 numbers. The attorney tells you on the record that they phoned those 3 numbers, and the call was not picked up. I'm now at paginated page 9 of the condemnation affidavit. The following week, on the 16th, 17th, and 20th of February, the attorneys called those 3 numbers again, and again there was no answer. Then, when that didn't happen, there was a call that was placed through to reception. The receptionist, who is identified in paragraph 20 on page 10, gave a further 3 numbers. And if your ladyship looks at the 3 numbers listed in paragraph 20 and the 3 numbers listed in paragraph 19 on the previous page, that's paginated page 9, the first 3 numbers and the second 3 numbers don't match with each other, which means that in effect my attorneys were given 6 numbers to phone. None of them resulted in the calls being picked up, and none of those numbers taking accountability for the transcript. The transcript, with all due respect, is necessary because the transcript is relied upon in the drafting of the formulation of the application for leave to appeal. Then there was a follow-up on the 28th of February, and then thereafter there was communication with the court manager of this court, who referred the attorney to 2 named individuals. I don't think it's necessary to name them unless your worship wants to know their names. 2 named individuals. Then an email followed to those 2 individuals on the 2nd of March. Then there seems to have been no activity until the 6th of March, when my attorneys, during a telephone call, were told that the service provider who deals with the transcriptions was no longer the service provider. So in other words, from the 21st of October to the 6th of March, which is the first time we get to actually talk to someone about the transcripts, we're told that the relevant body that was appointed to do the transcription is no longer...
All right, those are live visuals from the Palm Ridge Magistrates Court. That's where we're listening to a case, of course, around a gender-based violence case that may very well change jurisprudence when it comes to how the courts respond to people in situations like that.